Hello and welcome to Courts This Week. I'm Dina Osha. In this special edition, we bring to you top stories of legal proceeding from courts, from lower and subordinate courts to high courts and Supreme Court. We bring a selection of major legal proceeding which made headlines this week. In the next half an hour, we will also inform and update you of all the important proceeding from the week. So let's start Court This Week. The Supreme Court has observed that it is only where a hospital provides medical services free of charge across the board to all the patients that it would stand outside the purview of the Consumer Protection Act. A hospital which renders free services to a certain category of patients while providing services which are charged to the bulk of others would not lie outside the purview of the jurisdictions of the consumer fora. The bench, comprising of Justices D.Y. Chandrachud, Indu Malhotra and K.M. Joseph, said. In this case, the complainant alleged medical negligence against a Sarvodaya Hospital and Safdarjung Hospital. The district forum dismissed his complaint against both this hospital as regarding the Safdarjung Hospital. The complainant was held not to be maintainable on the ground that the treatment had been afforded free of cost to the patient. The State Commission, though upheld the non-maintainability of the complaint as against the Safdarjung Hospital, found that Sarvodaya Hospital was guilty of medical negligence and directed it to pay a sum of rupees 2 lakh as a compensation. Allowing the revision petition filed by the Sarvodaya Hospital, the National Consumer Disputes Redressal Commission, that the finding of the SCDRC that Safdarjung Hospital was not amenable to the jurisdictions of the consumer fora was contrary to the decision of the Supreme Court in India Medical Association versus V.P. Shanta in 1995. The court noted that there is no factual material placed on the record to enable it to decide on whether the hospital satisfies the tests enunciated in the Indian Medical Association. Therefore, while dismissing the appeal, the court left open the issue as to whether 8 Safdarjung Hospital would be governed by the provisions of the Act. An intervention application has been filed in the top court highlighting the plight of the COVID-19 patients, exposing the alleged scam and malpractices adopted to rob the citizens of India in guise of a treatment. The application has been moved through advocate on record Manisha T. Karya in the ongoing public interest litigations filed on behalf of Sachin Jain, which has sought regulations of cost of treatment for COVID-19 at private corporate hospitals, averring that private hospitals are indulging in exploitative means and charging from the patients in an extortive manner. Escaping of rates was enforced by the state governments. The applicant earmarks 2 different hospitals that have heavily charged the patients from the family of the applicant in the guise of a pharmacy built. Therefore, the affidavit filed and suggestions given by the UOI are not sufficient to address the issue on the hand, as there is an urgent need for the specific guidelines and regulations for limiting the cost of pharmaceutical and other products for COVID-19. This will also help charitable institutes who are helping COVID-19 patients and even hospitals otherwise to save cost and serve better. The applicant contends as the current situation in India shows a sharp increase of COVID-19 cases, immediate implementation of certain aspects to salvage the situation across India before it's too late is extremely important. Along with the suggestions of the Union of India already stipulated before the court, as well as in compliance with the directions of the order passed by a bench of Chief Justice S.A. Bobde, R. Subhash Reddy and A.S. Bopanna on July 14, in the main plea, advocate Sachin Jain, petitioner in person, have argued that there must be regulations for all the entities, as government has given them unfettered powers to charge patients. In private hospitals that are dedicated COVID hospitals, there is no qualification as to how much the hospital can charge. Patients are being charged between 10 and 12 lakhs. Government has given them unfettered powers to charge, he said. After backing out from the Supreme Court order Smoke Tower project and consequently incurring the court's wrath, Indian Institute of Technology, Bombay has now agreed to supervise the exercise. Solicitor General Tushar Mehta informed the bench of Justices Arun Mishra, B.R. Gawai and Krishna Murari that a memorandum of understanding has been signed with the IIT Bombay, which has now agreed to supervise the Smoke Tower project. Mehta stated that the project would take a total of 10 months to be completed and that this period could not be curtailed further. When Justice Mishra sought to know when the foundation work would start, it was submitted that the foundation date would be revealed next Monday. As per details of the affidavit filed by the Centre before the Supreme Court, IIT Bombay will oversee the project, whereas National Building Construction Corporation Limited will construct the tower. Tata will be responsible for this installation. The bench asked Mehta to place the MOU on record and sought to be informed of the funds required for the project and the time needed for its completion. This after the Apex Court pulled up the institute for backing out of the project and warned that it would take contempt action against it. To this, Mehta had stated that the technical aspects would be covered by the IIT Bombay and the parts had to be procured from the Minnesota, United States. The court had then asked the center to file a detailed affidavit on the utilization of funds and the timeline of the project. In his affidavit filed before the Supreme Court, Chairman Emeritus of the Tata Sons, Ratan Tata, had said that he is disappointed to see former Executive Director Cyrus Mistry use the clock of operations and mismanagement around his loss of office. A cross appeal was subsequently filed by Cyrus Mistry, who sought more relief from the court than was granted by the NCLAT. The Supreme Court, agreeing to hear this appeal, has bunched all the appeals arising from the NCLAT's December 2019 decision together. It is in relation to this batch of the appeal that Ratan Tata had filed his affidavits. He called Cyrus Mistry a Trojan horse whose actions were undignified. Tata says that it is a matter of record that while the company's board had appointed Mistry as the executive director, it was the same board that nearly unanimously decided to replace him. Tata's affidavit was all give a sharp yet worldly response to Mistry's questionings of the performance of the two men at the helm of affairs at the company. If Cyrus Mistry seeks a certificate of his performance, I cannot bestow on him, and prudence demand that he should leave the judgment to the stakeholders. But he would not do so because he does not believe in shareholders' democracy. Tata also says that he would like to bow out of any debate around his performance as chief executive of Tata Sons and would neither like to defend nor endorse his performance during the tenure in response to the attack from the Mistry. Bihar police had said in the affidavit filed in Supreme Court that Riya Chakraborty plea to transfer case from Bihar not maintainable. She wanted Sushant Singh Rajput's money. The affidavit states that Rajput father, who had filed the complaint in Bihar, had alleged that Chakraborty had the sole intention to grab crores of rupees from the deceased actor.
The Bihar police has stated before the Supreme Court that Riya Chakraborty's plea seeking transfer of the FIR filed in the Sushant Rajput suicide case from Patna to Mumbai is not maintainable. In its affidavit filed in the Apex Court, the state police has averred that Section 406 of the Code of Criminal Procedure (CRPC) cannot be invoked for transferring investigation from one state to another. Further, the affidavit avers that Chakraborty has not mentioned anything in the transfer plea to substantiate bias against her except for the general and bald allegation that the complaint has been lost due to influence of the informant of the case. The affidavit states that Rajput father, who had filed the complaint in Bihar, has alleged that Chakraborty had the sole intention to grab crores of rupees from the deceased actor. It states the deceased actor wanted to leave film industry and do organic farming in Coorg. However, the petitioner stated blackmailing the deceased actor by saying that she will give his medical report to the media and prove him mad, after which he will not get any kind of work. Though the Bihar IPS officer, who was forcibly quarantined on 2nd of August, was released this morning. The affidavit says the quarantine was an afterthought on part of Mumbai police. The Bihar police further states that the investigation before the Mumbai police is only with regard to a case of unnatural death under Section 174 CRPC, which has very limited scope. Such an investigation cannot be categorized under information relating to commission of cognizable offence within the meaning and import of Section 154 CRPC, the affidavit states. Earlier this week, a single judge bench of Justice Rishikesh Roy had posted the transfer petition filed by Chakrabarti for the next week and had sought replies from the Mumbai and the Bihar police on the issue. Mumbai police was asked to update the court on the status of the investigation. The genesis of the case lies in the complaint made by deceased actor Sushant Singh Rajput's father to Bihar police, where he alleged that Chakrabarti is guilty of abetting his son's suicide on 14th of June. Chakrabarti has now been named by the Central Bureau of Investigation in the FIR lodged to investigate Sushant Singh Rajput's death. Bureau report.
The Supreme Court heard a matter relating to contempt petitions against the Jammu and Kashmir administration. During the hearing, Supreme Court asked Centre if any part of the Jammu and Kashmir can get 4G internet. Government has to respond by August 11th. The internet service in various parts of Jammu and Kashmir stand restricted at 2G internet speed till August 19 as on date. A bench of Justices N.V. Ramana, R. Subhash Reddy and B.R. Gavai heard the matter and asked Solicitor General Tushar Mehta, appearing on behalf of the Union Territory of Jammu and Kashmir, whether it was possible to restore 4G internet services in some areas. In the previous hearing, Senior Advocate Huzaifa Hamadi has informed top court that Lieutenant Governor was of the opinion that 4G internet services should be restored in the region. The Supreme Court, while hearing a contempt petitions against the Jammu and Kashmir administration, sought to know from the Solicitor General Tushar Mehta if fast-speed internet service can be restored in any part of Jammu and Kashmir. The internet speed in many parts of the region stand restricted at 2G speed and as on date. Solicitor General Tushar Mehta, who represented the centre today, told the court that he would have to give instructions as regards the questions of possibility of restoration of 4G internet in the region. As such, the bench of Justices N.V. Ramana, R. Subhash Reddy and B.R. Gavai adjourned the hearing in the case till August 11th. The top court clarified that the centre replies it will decide on the contempt, even though Mehta insisted that there was no contempt and the May 11 order of the top court was complied with. On July 28, a Justice N.V. Ramana-led bench had asked the centre to verify if Jammu and Kashmir's administration has sent any communication to the Ministry of Home Affairs for restoring 4G mobile internet services in the Union Territory. This fact was brought to the top court's attention by the petitioner, NGO Foundation for Media Professionals, in an affidavit filed in response to the centre's reply on the position. Senior Advocate Huzaifa Hamadi stated that apart from J&K, Lieutenant Governor G.C. Murmu, even Chief Interlocutor Ram Madhav had asked for restoration of 4G internet connectivity. The senior lawyer argued that since the centre had maintained in its reply that the final call on the matter would be taken by the government of Jammu and Kashmir, the statement were of importance. It was submitted that on July 26, L.G. Murmu said that he was not worried about how people would use the high-speed internet, as Pakistan would continue to spread propaganda irrespective of the internet speed. The petitioner had alleged contempt of the top court's 11th May order, claiming that centre had not reviewed the 4G restrictions as no order had been placed in the public domain. The centre had filed an affidavit in July claiming that it was not possible to restore 4G services for the present, but left it to the UT administration to decide. The NGO sought restoration of high-speed 4G internet services, saying patients, doctors and the general public were unable to assess the latest information, guidelines, advisories and restrictions about COVID-19 pandemic because of the restrictions. It pointed out slow internet speed makes telemedicines or online consultations impossible. The petitioners are presented by Senior Advocate Huzaifa Hamadi with Advocates Shadan Farasat, Apar Gupta, Vrinda Bhandari and Devdatta Mukhopadhyay. Bureau Report. The Supreme Court has said that it will not close the Enrica Lexi case concerning the shooting of two Indian fishermen off the coast of Kerala by Italian Marines without hearing the families of the victim first. To this end, the court has asked for the families to be made parties to the case. The apex court has also asked the Italian government to ensure that adequate compensation is paid to the families. The court will hear the case next after 1 week. The bench of the Chief Justice of India, S.A. Bobde, with Justice A.S. Bopanna and V. Ramasubramaniam, was hearing an application filed by the centre seeking disposal of all the pending cases against two Italian Marines who are accused of killing the two Indian fishermen while at sea. The court was told by Solicitor General Tushar Mehta that the centre has decided to accept the award that was passed by the Permanent Court of Arbitration at The Hague, which precluded India from exercising jurisdiction against two accused. On this, the Supreme Court flagged two issues that arise from the centre's decision, one pertaining to the questions of compensation of families of the victim, and the second involved the Supreme Court's previous order which directed for the trial to go on. The court questioned as to why the centre approached the Supreme Court directly for the disposal of cases without approaching the trial court first, where the families of the victim are also a party as opposed to before the Supreme Court. Mehta, while assuring the court that the families of the victim can be brought before the Supreme Court, also submitted that the Italian government has assured that the two accused will be criminally prosecuted in their home country. The PCA ruled that India did not breach provisions of the United Nations Conventions on the Law of the Sea. In the case, it did not have the jurisdiction to prosecute the Italian Marines. Massimiliano Latorre and Salvatore Gironde, the centre, informed the Supreme Court that since it will abide by the award passed by the PCA, all the cases pending against the two Italian nationals ought to be disposed of. Advocate Yatin Oja, whose senior designation was stripped off by the full court of Gujarat High Court, offered before the Supreme Court to make an unconditional apology to the High Court for his remark against it. Taking note of this, the Supreme Court deferred the hearing of his petition challenging the High Court decision for 2 weeks, expressing the hopes that the High Court will consider Oja's representation in the meantime. The bench, headed by Justice S.K. Kaul, expressed its unhappiness over the remarks of Oja, who is also the president of the Gujarat High Court Advocates Association. The kind of the amputations you made, I don't agree with anything that. If seniors like you begin making such amputations, what would the juniors who enter the professions? Justice S.K. observed. Justice Kaul also said that it was incorrect to say that only certain matters were being listed by the court and that the registry was working very hard. Grievances people can have, but to say that only certain category of matters are being listed, to make amputation that certain other matters are being listed and not the rest is not correct. The registry is working very hard indeed, Justice Kaul said at the outset. Oja said that he was also offering an unconditional apology for his remarks. I seek forgiveness. I offer my unconditional apology. I did so before the full bench in Gujarat HC also. In my career, I have never done something like this. I became a senior at 44, he said. Senior advocate Shekhar Nafade, who appeared for the Oja, said that his remarks were out of his anguish before the plight of the young lawyers. The bench, however, asked the Nafade to refrain from justifying Oja's behavior. The Delhi High Court has allowed the University of Delhi to proceed with its online open book examinations for the final year undergraduate students scheduled to start from August 10th. Though the court declined the students' plea to stay the exam, it passed a slew of directions to address the various concerns raised by the student. The court directed the Delhi University to comply with its direction and communicate the same to the Common Service Centre Academy. The Delhi High Court has given its note to the conduction of the online open book examination for final year students of Delhi University. The online OBE is set to begin from Monday, August 10th. The order was pronounced by a single judge bench of Justice Pratibha M. Singh in the petition preferred by students of Delhi University. The court had directed Delhi University and UGC to comply with the direction passed in the order. Directions to Delhi University include the following. Question paper to be uploaded on the portal and sent to students' email ID. Students to be given extra hour for uploading the answer sheet. Auto-generated email to be sent confirming receipt of the answer sheet. Details of the nodal officer, central email ID to be published. Common Service Center to notify all its center by the end of the day. There shall be a grievance officers to address the issue raised by the students. In case of a non-redressal complaint to be forwarded to the grievance committee. Issues of privacy of data and storing of data will be considered at a later stage after pleading in the case are complete. While steering away from the challenging the UGC guidelines which have made it compulsory for educational institutions to conduct a time-bound examination for final year students, the petitioners has vehemently argued that OBE was in violations of their rights guaranteed under Article 14, 16 and 21 of the Constitution of India. Defending DU's decision, lawyers argue that in view of the UGC guidelines, OBE was the best way forward and a student need not have very high technology at his or her disposal to sit for the examination. DU submitted that since the decision to conduct the OBE was taken by very senior academicians and experts as a rule of prudence, the court should not interfere in the academic sphere. The court was assured that the process had inbuilt safeguards, including availability of common service center for students with no cyber infrastructure, grievance committee and helplines, and that the student would always have the option to sit for physical examination, which would be conducted in September 2020. Order in the challenge was reserved by the court on Wednesday. The issue of the DU's preparedness to conduct the examination and safeguards for PWD category students is the subject matter of petitions pending before the division bench headed by Justice Hema Kohli. Bureau Report.
The Delhi High Court has dismissed a petition challenging the order directing Indian Army personnel to delete accounts from the social networking platform like Facebook, Instagram. The order was pronounced by division bench of Justices Rajiv Sahai and Law and Asha Menon in the petition preferred by the Indian Army officer Lieutenant Colonel P.K. Chaudhary. In his petition before the court, Chaudhary had submitted that he was an active user of Facebook and that he used the platform to connect with his friends and family when he was posted in remote locations. The petitioner contended that the ban on the use of the social networking platforms violated his fundamental rights, including the right to freedom of speech and expressions and the right to privacy. Since the policy was not a law passed by virtue of Article 33 of the Constitution, the provisions under it could not be modified, it was said. Apart from a direction to the authorities to withdraw the ban, a declaration was also sought to the effect that the Director General of Military Intelligence was not empowered under the constitutions or under any other law to modify, arm or abrogate the fundamental rights of the armed forces. Last month, the court has refused to grant interim relief to the petitioner since the matter was related to the safety and security of the country. Well, that's all in court this week. Thank you so much for tuning in. Keep watching APN and stay safe.